Okay, are we ready? Okay, morning everyone. Thank you for coming to another one of Country Living Essentials. As we build up a database for people who want to move into the country, we're looking at all the skills, the expertise, the advice you need. Today we've got a very, very important topic, and this is not going to be the beginning and end all of buying and financing a country living property. This is an introduction to a country living property, how to buy it, what systems you can buy it in, what models you can follow, what are the advantages tax-wise, all these sort of things. So if you've got questions, start building up your questions. We have two professionals here who've given up of their time, which we really appreciate. We have MADELYN BARNARD, which is a conveyancer attorney, and she'll be starting off the talk, giving us advice as far as buying properties, things to look out. You know, we know there's lots of pitfalls. And I would advise you, when you're looking to buy a country living property, get as much advice from people who have bought country living property about the physical aspects you need to look at, but get advice from a professional when it comes to buying. And we really appreciate MADELYN coming to give us that advice, because she's got no agenda here. She's got your best interests at heart. She wants you to make as little mistakes as possible. She's not here to gain financially, although she has a business. So when you do come, you can consult with her. You can use her if you would like to. So we really appreciate the time the professionals are giving to us. And so before we go in, I'd like to ask Pastor Donovan, would you like to open in a word of prayer for us?
Let us pray. Dear Lord, we thank you for another opportunity that you have given to us to consider these practical elements of buying a property. Lord, thank you that we can learn from each other. And I pray that you would bless the presentations and that it would be fruitful for each one of us. In Jesus' name, amen.
Amen. Thank you, Donovan. And a special welcome to the online viewers. And please note that all the talks we've had thus far, the one on soil, the one on solar power, the one on canning and preserving, they're all available on the Silverleaf YouTube channel. So you can go back and watch whatever you want. If you're not sure how to get it, you can ask someone and we will help you do that. MADELYN, over to you. Thank you.
Thank you very much, Paul, and everyone for the invitation. So I've been asked to just speak a little bit on the legalities of buying property, and specifically in this case, it will be agricultural property. So let me just say that whether you're buying property, whether you're buying a sectional title unit in a block of flats, or whether you're buying a freestanding home, or whether you are buying agricultural property, a lot of the structure is actually the same. The process is very much the same, but when we are buying farming land, then there are a few specific things that we do need to just take note of and look at as well. So the first thing when we are buying property, regardless of the type of property, to take note of is the Alienation of Land Act, Section 2. So in terms of that act and that section, if you buy fixed property, in other words, property that you can't pick up and move, then, so land, it has to be in writing and it has to be signed. So if you don't have something in writing and it hasn't been signed by both the seller and the buyer, you do not have a valid contract of sale. Then that is not your property. Okay, so that's the first thing to look out for. Now, the best advice that I can give you is before you sign anything, have a professional look it over, as Paul said, because that is the document that will govern the relationship, that will govern your rights and duties in terms of that agreement, and also the rights and duties of the seller. So I'm assuming this morning that I'm speaking to potential buyers, so I'll be speaking from that point of view as a buyer. So your rights and duties as a buyer. It's very important to check that you understand what your duties are in terms of that contract. So just perhaps a note that the seller is the person who gets to choose who they use as a conveyancer. The thought being that that is their I mean, a big part of your biggest asset that you ever own really is your fixed property. That's also the most expensive. It's the capital outlay that you put into it. So the thinking is that you want someone that you trust to handle your biggest asset. But from the viewpoint of the buyer, you are paying a lot of money. So you also actually wanted to pay it to someone that you trust. So the fact that you do not get to choose the conveyancer does not mean that you have to pay money to someone that you do not trust. You can actually pay it to a conveyancer that you do trust into their trust account, and they can issue guarantees to the seller's conveyancer. So that way everyone is protected and everyone works with someone that they trust. So the time frame that we're given this morning is very short, so I cannot in detail explain these things, but what I am saying is don't be alarmed by the fact that you cannot choose the person that you are working with, because you can get someone in your corner that you do trust to help you and advise you as well. And conveyancers work together like that all the time. It's nothing strange. The second thing that I want to just say before you sign that sale agreement is ask for a copy of the title deeds. And the reason why I say that is specifically when we are talking about agricultural land, there can be many things in those title deeds that we need to check. Servitudes. What will be your rights to water usage? What will be your rights of way? Where can you drive? Where can you not drive? When do you have access? Where's electricity? Where are those servitudes? Where can you put sewage lines and things like that? So it's very important to, especially when we're talking about agricultural land, there are very many servitudes and conditions and title deed, things that we have dominant and servient properties because farmland, usually, so you have one road that everyone uses, but that road actually runs across many properties. But you only really have the right to the little bit that runs over your part. So now you have the right to use that, but your farm is number 10 in the line. So you need to be able to use the right of way. So all those things are contained in the title deed, and they can be quite technical and quite tricky. So I do advise, together with, before you sign an agreement, ask for a copy of the title deed and have a professional look it over and advise you as to what is actually going on there, what rights you have in terms of the servitudes, and what your duties would be in terms of the servitudes and the conditions and entitlements there. So maybe just a word or two on the costs. When buying property, you obviously understand that you're going to be paying the purchase price. But together with the purchase price, there are lots of things that you also pay. The buyer is the one who really pays for everything. Okay, there's very little that the seller pays. The seller pays, so when you transfer property, there is, one has to have compliance certificates, and depending on where you are in the country, there are different compliance certificates that are necessary. So in the city of Cape Town area, one of the additional compliance certificates that we need is a plumbing certificate, and that's in terms of the City of Cape Town bylaws. So if you're buying outside of the City of Cape Town area, you may not need a plumbing certificate. Up country, so in the Western Cape, Eastern Cape, and KwaZulu-Natal, you also need a Bora beetle certificate. But in the Gauteng area, you don't need it there. So depending on which province you're buying in, you may need different types of compliance certificates. The one certificate that you will always need, whether you are, doesn't matter where you're buying, is an electrical compliance certificate. So, and that's the duty of the seller, to provide you with an electrical compliance certificate. Okay, so that's the cost for the seller. But for the buyer, you will pay the purchase price, you will pay the transfer costs of the conveyancing attorney. If you are buying with a mortgage bond, you will also be paying the costs of the bond registration attorney. And then there is, of course, our Mr. Taxman, who always wants some money as well. The amount that you pay to SARS depends on a few things, and I'm not going to say too much about it because Celia will speak to that, but you're either paying VAT or you are paying transfer duty. So people, I often get this phone call, I received the bill, can you just explain to me what's the difference between transfer duty and transfer cost? Transfer fees is what you pay the conveyancer. Transfer duty is what you pay to SARS, okay? So no one can give you discount on transfer duty. That is what that's tax, okay? That's what you pay to SARS. And that is calculated on a sliding scale. How do we know when we are paying VAT or when we are paying transfer duty? That depends on the VAT status of the seller. So if the seller is registered for VAT, then you pay VAT. If the seller is not registered for VAT, then you pay transfer duty. So that's another question to ask the seller. Before you sign the contract, are you registered for VAT or not? Because if they are registered for VAT, then VAT gets added on top of the purchase price. Okay, so be sure to ask that question because that can actually be a hidden cost that can really come and bite you. Okay, 15% on top of your purchase price, you can make the calculation, can come to quite a lot of money. Okay, and the same with transfer duty. Transfer duty is paid in addition to the purchase price. And the one thing that you must remember about transfer duty, so people think there is an option where you can register your bond for also covering the costs, okay? And that is true. But that money will only pay on the day of registration to the conveyancer. And transfer duty has to be paid up front because to be able to transfer property, we have to lodge for the deeds office a transfer duty receipt. And to get a receipt, you obviously have to pay. There's a question there? Yes.
When they advertise a property and they registered for VAT, are they liable to advertise the price including VAT, or is that price that's advertised, is that ex-VAT? So when you see that price on the contract?
Yes, so in South Africa, the price always has to include VAT, but sale contracts usually say purchase price, and then it adds the VAT. So the property, so if they are registered for VAT, it must state that. So if it's not stated, then we can actually assume that the price already includes the VAT. But I have never seen a sale contract that includes VAT. Usually it's still on top, yeah, because they want they have an idea what they want in their pockets. Yeah. Okay. Where was I now? Transfer duty, cost. But so transfer duty has to be paid up front. So you have to have that as cash flow, is what I'm trying to say. You can get a bond that will pay your costs, but we can't wait until transfer to get that money because it has to be paid to SARS beforehand. Because there's no way to transfer property without a transfer duty receipt. And obviously you only get a receipt once you've paid the transfer duty. So that's something just to keep in mind and something that people don't always know and don't always make provision for in their when they're making their calculations. So just in terms of the process, I'll just very quickly run through it because the process of buying property can be quite stressful, especially if you are selling property to be able to fund the purchase of your new property, because then there's a move that needs to occur. There are practical implications of, vacating and moving and so on. So in terms of the process, once you have signed your agreement of sale, that then goes to the conveyancer. If you are applying for a bond, now starts the process of bond applications and all the credit checks that the banks have to do and all of that. So usually make sure that you have enough time negotiated in your contract for having a bond approved. As a standard clause, usually it's 14 business days, but I prefer to advise my clients to ask for 21 business days, because the amount of paperwork that you have to do for bond approvals is quite daunting, and you don't want to sit with a situation where you have to take the first offer that comes. You want to be able to shop around for the best interest rate possible, because you would be surprised what just 1.2% can do to your overall payment over 20 or 30 years. So you want to have time to be able to shop around and accept the best possible offer that you can on your bond. And your offer will be subject to bond approval. So which means that if you are not approved for a bond, then the contract is not enforceable and everyone moves on with their life. Okay, so you can't be forced then to buy the property even though you don't have finance. So it's subject to. Once the bond is approved, then the transfer documents has to be drawn and the conveyancer will contact you to come and sign. At that point, you also then pay the transfer costs, transfer duty, all the things that you have to pay up front, and issue guarantees or pay the cash if you're paying cash. And then the conveyancer will start doing the applications for the rates clearance certificate. So the municipality has to be contacted. The reason for that being, and this is often what almost takes the longest in the whole process, depending on which municipality you're working with. So the reason for that is so that the buyer takes a property that does not have arrear rates outstanding on it. So you take it clean from a zero. And that makes a lot of sense. I think we can agree to that. You don't want to take over a property that has arrear rates from a previous owner. So you take it over at a zero, and the municipality issues a certificate that says everything has been paid, and we are happy that this can be transferred. So that's the transfer duty certificates, the compliance certificates, and then when we talk about agricultural land, the big question is the portion that you are buying, has that been registered? Okay, so now we're going to talk about subdivision. And this is specific to agricultural land. So the Subdivision of Agricultural Land Act 70 of 1970 states that farming land, agricultural property, cannot be owned in undivided shares. So what that means is if you are married out of community of property to your spouse, you cannot each buy a half share together. You can only register that property in one name. So either one of you, or, and this is why people buy agricultural land, either in a company or in a trust, okay, because you cannot own it in undivided shares. If you're married in community of property, you and your spouse can own it together because you are seen as one estate. So it's not actually undivided, it's one estate, and so then you can buy it like that. But if you're married out of community of property, so that means you can't buy it with your brother or your best friend or brother so-and-so who sits next to you in church every Sabbath. Okay, so you have to buy it. You can only have one entity owning it. So then the question becomes, how do we structure something like that? So you can either register a PTY or you can register a trust. If you register a PTY, then you and whoever it is that you wish to buy the property with will be the directors and the shareholders. But know then that you do not own land. The company is the one that owns the land. You own shares in a company. That's that. Okay. And then your shares you can leave to your children or whoever you want to benefit from that. And the tax implications of that, Celia will speak to that. I'm not trained to speak on that, and that's why she's here, and I know she'll do a beautiful job at that as well. The other option is to register a trust, where you will be the founder of the trust, you will be a trustee in the trust, and you may be a beneficiary in the trust, but you cannot be the only founder, the only trustee, and the only beneficiary. Okay, that's illegal, so that will not be allowed. A trust like that will not register. So you need to have at least another person being a trustee with you or someone else being a beneficiary with you. And a trust also works nicely because then you can make your children the beneficiaries of that trust, and a trust can exist in perpetuity as well. So, and the same with a company, it has perpetual existence. So even when you pass away, that entity still continues. And another thing that's very nice about buying in a trust or a property, a trust or a PTY, is that because you don't own the property, the entity owns the property, it does not form part of your estate for estate duty purposes either. Okay, so that's also a nice way of bringing down estate duty, but there are other tax implications that Celia will explore just now when I am done. So when you are thinking about buying in a trust, you have to know that you cannot sign that deed of sale before the trust has not been registered. That would be null and void. Okay, so you can't, the trust has to exist, and the trustees have to have taken a resolution to agree to the sale, and in that resolution appoint one of the trustees to sign the document on behalf of the trust, and only then can you now go and sign that document. So many people say, we want to buy in a trust, can you start registering the trust, but here's the deed of sale. Then I say, I'm sorry, all of this is, I'm sorry, I can't do any of that. So you have to have the trust before you buy the property. Okay. A company is a little bit different. You can enter into contracts on behalf of a company that still needs to be registered. Section 21 of the Companies Act makes provision for that. And if you are wanting to do that, see a professional, because there are very specific ways that you need to name that, and you have to tell the seller that that is what you are doing. Okay, but there is an option to do that. So agricultural land cannot be subdivided without the permission of the Minister of Agriculture. So if you are buying in a company and you are a few people together, again, I cannot stress this enough, you do not own land. You own shares in a company. That's what you own. So you can't now say, okay, well, we've all bought together, so you take that area there, I take this area, and that's actually illegal, okay? Because the structure of it, the law looks at what you are trying to do, not what you say it is. Okay, so it will give effect to, in effect, what it is that you are doing. So if you are buying a piece of land that has been subdivided, okay, because you can get permission if the minister gives you permission, and then you can sell off parts of the land. So if you are buying a piece of property that was newly subdivided, the question that you have to ask is, has that been registered? Because the process of subdivision is like you have to get permission from the minister, then the surveyor general draws maps, okay, and that gets registered. But until that new piece of land, so while in life, let's say, in the situation, that is now a separate piece of property, until it's been registered in the deeds office, it's not. They don't know that that's been subdivided. And in South Africa, the deeds registry is where we have all record of properties. So until it's registered there, it's actually not a separate piece of land. It's been surveyed, but it hasn't actually been registered. So until a title deed has been issued for that land, it's not separate yet. And if there is no title deed or certificate of registered title for that piece of land, then you have to add to the registration process permission from the municipality to register that. And the reason for that is when you apply to the municipality for the subdivision, they will have their various departments have conditions to the subdivision. So water and sanitation will have conditions. Electricity will have conditions, because that property now needs to be prepared with those services. And then the municipality needs to issue a consent to say, we are happy that all conditions have been complied with, and now this piece of land can be registered. So if that hasn't been done, keep in mind that that process can delay your transfer easily up to 3 months. Okay, so then you would add time to your registration process. So the biggest question that I always get is, how long does it take to register property? And my answer is, how long is a piece of string? So it really depends on the situation, where you are, if there is subdivision. If everyone works together and there's no strange conditions that we need to deal with, you can get a property registered within 6 weeks, okay? But if you still have those subdivision conditions and consents that need to take place, it can take longer. You have a question? And then I must wrap up, so Celia can also come and speak.
Maybe I can, on this matter, how possible is it, let's say you buy it subject, so it's not in the deeds office yet, registered, that somewhere in that process, maybe they don't accept the municipalities.
Yes. So if you're buying subject to subdivision, then the contract cannot be, it's not enforceable until it has occurred. So then you're buying subject to, but that's then a condition that has to be fulfilled before transfer can take place. So however long that takes then. So as a buyer, you can decide what I would advise is you must then decide for yourself, how long are you willing to wait? And then make that a condition of the contract to say, subject to, provided that by such and such a date, this is completed. So that it's not an unending, Correct, yes. Yeah, that would be a way to find certainty, at least for timelines, yeah. Okay, one last thing that I want to say on agricultural land is when you're buying agricultural land and you allow people to stay there, who are not owners or anyone to stay there. So our country has very strict laws relating to evictions. So it's all good and well as long as things go well. But unfortunately, the life that we live in, things can go wrong. And I don't think that we must be unrealistic about that. So I do just want to say a word or two on this. When you do evictions on property that is not agricultural land, we have to follow the Prevention of Illegal Eviction Act. And an application like that you can bring in the magistrate's court where you are, and you can deal with that application there. It is lengthy and it is costly, but eventually you will be able to get an eviction order. But when you are dealing with agricultural land, you have to bring your eviction proceedings in terms of the Extension of Security Tenure Act, ESTA, it's called. And that application you can only bring in the High Court, which immediately it's more expensive. And the timelines, the required notice periods is much, much longer. So with PI, it's 14 days that you have to give notice that you're wanting to bring an application. With ESTA, it's 30 days that you must give notice. And the High Court rolls are a lot more inundated than the magistrate court rolls. So if you do need to look at evictions from agricultural property, it's very expensive. It's a very lengthy process, and it's not great. Yeah. Yes.
Sorry, when you say very expensive, just give us a rough idea.
You can easily go up to 200, 250,000 rand. Yeah, it's expensive. It's hundreds of rands. It's not thousands. Yeah. So because it's in the High Court, you're paying attorneys, you're paying advocates, you're paying sheriffs, you're paying all sorts of costs. So it's expensive, and because how long the process is as well, it's a protracted process. So legal costs can be very expensive for that. Yeah. Okay. Celia, I'm going to hand over to her now, and then when she's done, I'll come back and we'll have more questions.
Good morning, everyone.
Morning.
The microphone's working. That's a good sign. Thank you all for coming out, and especially coming out on a Sunday morning so early. It shows lots of commitment and hopefully lots of potential buyers. So when I looked at the invitation, staring at it during the week, this invitation, trying to figure out where to start, because it can be such a complex topic, or very simple, so it all depends how deep you go into it. I spotted an interesting irregularity. As accountants, we are trained to spot differences or irregularities. Who can spot something there that is standing out to you? It's not something big, so so we've got practicing and practicing. So who's right and who's wrong? Well, no, it's not. No, say, look at it. So we are saying, it just depends where you come from. So that gave me inspiration to go and say, listen, there's no right fit of an entity. All the information I'm going to give you, you just have to take it and filter it through to your unique situation and read the fine print. So yes, I just want to then skip on to this quotation. So why we are here today is we all actually aspire to get a country living or get somewhere out in the country. And it stems from this quote from Ellen White, which says, "The Lord desires his people to move into the country where they can settle on the land and raise their own fruit and vegetables, and where the children can be brought in direct contact with the works of God in nature. Take your families away from the cities," is my message. So I think that's a reason why we all aspire to be moving out to the countryside. So today I'm going to try and help you a little bit with the financial planning and considerations when looking at something like this. So I'm going to talk a little bit about the factors to consider before purchasing a property. Which entity should you do it in? The tax implications thereof, and some of the bond and finance options available. I don't know if you can see there, but it doesn't matter. The fine print is for me. So 7 things to consider before buying a property is the location. So we've just looked at the quote from Ellen White, and we know we need to be looking for somewhere specifically out in the countryside. But the location also is quite an important matter. Study your property market, do lots of research, communicate, let's start again. The commuting distance between you and your family and your church community and where to find essential products is also going to play a big factor. And factors like flooding risks, droughts, and things like that needs to be considered. Then Madeleine also touched on this, the hidden costs. So consider transfer duty can be quite high, conveyancing costs, the deposits for light and water, estate agents' costs, the bond fees, cancellation costs on the bonds. Do a proper property inspection before purchasing. Look at all the repairs and maintenance that needs to be done before it will be to your liking or in a livable condition. Time your move so that you don't pay double. If you have to move out of a rental property, time it so that you can do it in the same month, just lapsing or not paying double fees in that month. Then number 3, do your research. Ask a lot of questions. Why has the property been on the market so long? Why is it not selling? Why is the price so low or so high? So do a lot of research and ask a lot of questions. Why is it struggling to sell? And then number 4, put down a deposit. So save up. The higher your deposit, the lower your installments will be. And then number 5, a bond. So if you're going to, well, most of us would apply for a bond. I can't stress highly enough how well we work as a group, our tax shop group, with bond originators. So they take out all the paperwork. So you would tell them about your unique situation, what your company does or what you do, give them all your information. They will then go out into the market, find the suitable bond for you with ABSA or with all the various banks, which they've got a good relationship with. So they do all the hard work. And it's no additional cost to you. The banks actually give them commission to find clients for them. So that's something quite nice to have. And then probably number 6 should have been first on the list. Look at your budget. Buying farmland is probably one of the most expensive investments in assets that you can do, because there's so much hidden costs, so much drainage on cash flow. The pump breaks. So you have to do a proper study. Can you afford it? Have you done your budget? What will you be selling? Is there a market for the produce that you are selling? Investments for the property is expensive, so it's generally not a good idea in the short term. You should at least be able to hold on it for 5 years. Have all your financial ducks in a row when it comes to property can save you quite a bit. If you are a cash buyer, you can negotiate your price quite well. If you're not a cash buyer and you're going to bond your property, have a pre-approved bond so you can save time and money on that as well. Okay, so how to buy agricultural land? We've got a few options there. The most common of these would be your sole proprietor, where you are the individual buying the land or the property. You've got a company in the trusts, partnerships, or going in with family and acquiring companies with other church members. The golden rule there is avoid at all possible, if at all possible. It never ends well. So I know it's not always easy to do that, because we need some funding, or we need this, but it always ends badly, where the one party can't contribute anymore, and you see a lot of families ending up not speaking to each other anymore about falling out. So avoid at all costs. So I'm going to tell you about my ideal structure, which I will come to in a bit, but then you've got the company, the trust, and other. So sole prop is the individual. We're going to skip the buying together as a partnership altogether, because I would not advise that. Companies, you can either have a private company, the normal companies that we know, or you can have it structured as a small business corporation, which attracts quite favorable tax rates. And then trusts with very flexible options. You've also got then other options where you can have a leasehold purchase, or with 99-year lease agreement terms, which you can also structure that after the 99 years, your children or your family members can have the option to renew that lease. So that's also some favorable options in purchasing land, which is quite an easier way to do it as well if you don't have capital.
So just from the Agricultural Land Act, any lease agreement longer than 10 years, you have to have the consent of the Minister of Agriculture, because that's really seen as a subdivision. So for agricultural land in particular, that one can be tricky, and you would have to get the consent again for renewal.
Yes, I was sort of more thinking here of a small holding. Yes. So a small holding would be anything, well, different banks see it in different ways. So small holding would normally be something smaller than 5 hectares, right? Where you can do a leasehold. So you would have a farm, in this particular situation, you would have a farmer that gives you a leasehold agreement to farm on a piece of land not bigger than 5 hectares. So smaller entity, a smaller piece of land with your house on it. So you would own it, you would lease it for 99 years, with always the option, sometimes not the option, but most of them will have an option to renew within 99 years. And you will have that then also in your agreement that some of your children would be able to renew that. The downfall of that is that if you can't renew in the 99 years, your piece of property goes back to the original owner. So the farmer would then take your house or whatever you've got on that. So that's one option. And then there's another option of fractional ownership, which we will get to in a bit more detail later on. Yeah. Okay, so then just a little bit more detail into the tax considerations between an individual, the sole proprietor, just the tax rates. So the taxes on individuals range on a tax scale, so anything from 18 to 45%, depending on your income stream. Then a company, 27%, or small business corporations, if you qualify, can be very favorable from 0%. 7 and all the way up then to the normal tax rate of 27. And then trusts, 45% flat rate. But there are favorable rules that you can use. There's a conduit rule where you stream the income in the same form down to the beneficiaries, where the tax is not then, the trust is not taxed in the trust, but it's taxed at the individual basis. So that's what we'll get. So as you can tell, trusts are quite a favorable way of purchasing land, and the reason will be that it's quite great for succession planning. So you will pay transfer duty once, and you will then be able to leave the property in the trust for your children or children's children. So it gives you continuity because the trust doesn't end, it doesn't dissolve, and it gives you asset protection because it's a separate legal entity to yourself. It's also very flexible, it's versatile, so you can structure it the way that you want it, and you can specify in the trust deeds how you want this trust to be managed. As I mentioned before, it's got lots of tax benefits. If it's properly structured, it can offer significant tax benefits in potential savings on estate duty, capital gains taxes, and donation taxes. The cons for setting up a trust is it's quite costly. It's not like a sole proprietor where you can just start off and go. You will have to set it up properly, and you will have to have appointed, like Madeleine said before. You can't be the donor, the trustee, and the beneficiary. You'd have to have at least 3 trustees, and it can't be all the same person. It's also a little bit complex in that you have to structure it correctly. And we see it quite often where it's a badly structured trust. So the intention was there to set up the trust, but it doesn't have a bank account, and the trustees aren't keeping up to date with all the trust minutes, and yeah. So it can get complex, so I'd advise to get it done professionally. And the loss of control. So you no longer, as a person, as an individual, own the assets, but it's owned by the trust. What did I want to say there as well? Yeah, so the trustees have the fiduciary duty to act in the best interest of the beneficiaries. The individuals may not have direct control over how the assets are managed. Okay. Just a little bit more about the individuals then. The benefits of having an individual set up. It's easy to set up and there's low costs. You have full control and ownership over the assets and the business. And in the company, it's limited liability. So the company is a separate legal entity, so it's not in your own personal capacity. There's also the added benefit if the company that you are purchasing the property in is VAT registered and the seller is VAT registered, that you can skip transfer duty altogether because you only ever pay transfer duty or VAT. You don't pay both of them. So in the case where the company is VAT registered and the seller is VAT registered, it will pass through, and it's a going concern. And it must state that in the contract. It can pass through as a zero-rated tax. So you can save quite a lot of, if you can imagine 15% on a property is quite a lot of money. Yes, please. As long as you don't ask a question.
No. So from the conveyancing standpoint, that is a very good way to structure it, but you have to be able to prove that you do have a going concern.
Yes.
So, when we do, in that case, we have to lodge a transfer duty exemption certificate for conveyancing purposes. And when we apply for that certificate, that is when we then have to prove what the going concern is. They don't just give us an exemption certificate just because we say it is. So if it's a rental agreement on the land or whatever, that needs to be proven at that point. So yes. It's important. And as you said, the sale contract also specifically has to stipulate that. So once again, if that is how you're structuring it, see a conveyancer before you sign, because once it's signed, SARS does not allow you to correct it with an addendum later.
And
it has to be
maybe just
from the beginning.
Explain a going concern. Are you all familiar with the term going concern? No, you probably,
Okay.
you've got it.
Madeleine, don't you want to go in front? There. Grab the mic there, then everyone can see you.
No, please do.
So a going concern is more than just the property. You have to be able to prove that you are conducting a business on that property. So it can be something as simple as a rental agreement for someone to store things on the property, like a storeroom or something. But again, when we're dealing with agricultural land, we may have a problem with subdivision, because anything that makes it look like there's a portion. So if it is agricultural land and it's not exempted from Act 70 of 1970, then you may have a problem. But the point is, it's not just the property. There has to be a business that's being conducted on the property that you are selling with the property. So in other words, the seller can't then hold on to it. It has to be transferred with the property as well.
Yes.
And your contract has to state that it is a going concern and that the property, that it is, the business is being sold with that, and you have to be able to prove the business. So you can't just state it in your contract. So if there is a rental agreement, for example, that rental agreement will be submitted to SARS to be able to get the transfer duty exemption certificate.
Yeah, or even something as simple as just taking over an existing small...
Madeleine, just sit there.
Yeah, it's
Keep
probably
the mic
easier.
and you can sit there.
No, please,
No, sit there.
Yeah, it's better. So even if you're taking over a small farming business and that is registered for VAT, which it normally is because you have a lot of input VAT that you can claim, then you can take over that existing business because that is a going concern and you're going to continue with that farming business. So that will also qualify. And probably at this point, it's probably, whilst we're looking at the company structure, my preferred way, if it was me purchasing a property in the countryside, I would buy the property in the company and have the shares owned by a trust. So then that is an easy way of then saving on your transfer duty and then also your legacy is sitting with your children in the trust and it just can be passed on in generations. So then the trust sits then with the shares and your operations still happens in the company. So you would have all your VAT operations and all your farming activity in the company, but the trust then sits with your share.
Sorry, could you just explain that a little bit more exactly? How would you benefit? You've got the company and you've got the trust. Just explain a little bit more on that.
Okay. So the company will purchase the property, and the reason why I would do it like that is if your company is already VAT registered and the seller is VAT registered, you will save the 15% on the transfer duty. And you also then have the farming activities happening in the company, and the company is VAT registered. So then any profits that you make will be made in the company, and it's a lower tax rate than in the trust. But then if you want to leave your legacy going forward, the shares, the ownership of that entity is resting in a trust. So it's out of your personal hands, and it's also quite a tax beneficial way of getting your taxes done. But then you have to consider, we'll come to it a little bit later, company... Yes, you have another question?
No.
Let me also just ask, so Jan, it sounds to me that if you can set this up this way, when you buy,
yes,
then it's also an attractive position if you want to sell again.
Exactly.
Yeah, that might also be a consideration, because
Yes.
you might find a nicer property, and then a structure like that could help you to sell it, maybe. That's the
Yes.
question.
The structure is then for you, not for the next buyer.
But if the next buyer then could buy if you want to sell it, the next buyer is going to actually buy a company who has all of this activity and things in it, and it might be an attractive thing rather than just buying it clean, I think.
So
I don't know.
So it
From a
depends.
VAT and a transfer
Yes,
position and all
yes,
of that. Yeah.
from that point of view. It all depends on what your outlook is. So if you are an individual and you just want to live in the countryside and you don't have children, or you don't really want to leave anything for your children, you are just thinking of getting out into the countryside, then the individual route would be best for you because you don't want to leave anything. Because why I would say that is then you don't, when you come to sell it, you have a 2 million tax exclusion on your primary residence, on that piece of portion where your land is situated. So then, but then your estate will then still be taxed. So your viewpoint of what you want to do with this in future is quite an important thing to consider before you purchase it, and that will determine which legal entity you would choose. So this one that I'm choosing is for the long term. So you've got children and you want to leave that for your children, and it's quite a property that you know you won't want to sell in the near future because you want to have your legacy. That is a legacy setup. So otherwise, you would lose your primary residence. If you wanted to sell it in short run, I would probably go for a company, individual setup, not a company setup. Because
maybe
also,
I can also just respond to Jaco there, because companies can also sell property, so you can sell just the property from that, and then you still have your structure to buy your new company, your new property into. But if you're selling the company and you're transferring shares, yes, then you are correct. But you don't necessarily want to do that. You want to have that structure probably to buy the next property into again.
And then it's also worth at this point to mention that considering what you want to do with it is also important from the beginning, because if you're going for the individual setup, when you sell the property, the inclusion of that gain is 40%, whereas with the trust and the company, it's 80%. So it's a much higher inclusion rate. So you have to really, from the beginning, decide, is this something for the long run, or will I be selling it in the next 5 years? Because 40% including, so it's just what you include of that profit versus 80% what you include makes a huge difference. But we'll come to an example.
I just like to make a note here that, you know, moving in the country living community and working with the people, a lot of people have a very short-term outlook.
Yes.
They think the Lord's coming in the next 3 years
Yes.
or the next 5 years. And I think this is very important aspect to look at now. We have to plan for the longer term.
Yes.
Because, I mean, we're 180 years since 1844. You know, but so many people have this narrow mind look that the Lord's coming in the next few years, and they're like, oh, you know, it doesn't matter what entity and all of this sort of thing.
Yes.
But look at the generations that have passed. You know, it's 10 years, 20 years down the line.
Exactly.
So one really needs to look at these things, because I'm just thinking some people might be out there, oh, it doesn't, you know, I'm not worried about that. But we need to worry about these things, because it can cost a fortune down the line if you've used the wrong entity. And et cetera.
Yes. The planning is very important. So we've touched on all that. Yes. So let's go to the pitfalls of a sole prop if you're buying in your individual company. It's a costly estate duty. So when in the unlikely event of passing away, if you're sitting with lots of assets in your personal name, your estate duty taxes will be very high. So that's a reason why a lot of people try to get all of their assets out of their own personal capacity into a company or into a trust. So that is why we would recommend going for the trust and having the shares then, or the company and having the shares in the trust. So yeah, and also in your personal name, there could be a personal attack from creditors. So if you are in an active farm or an active farming community, and there's a guy that has his finger chopped off, unfortunately, you are personally being in the risk of being attacked whilst you are protected in a company. So that is one of the pitfalls. With a company then, yes?
What? So you say you're protected within a company. What about within a trust?
Yeah, you would also be, because it's a separate legal entity.
Okay.
You are separated from that. So in a company then, the taxes can be quite high when you distribute any of the reserves. So you are taxed at 27%, but then any funds that you want to take out of it at a later point will be a dividend. So dividend taxes are withheld in the company. So it's a further 20%. So it is quite a costly way of getting money out of it then. But there are other ways of doing it. So, and also company has got a higher setup cost than an individual. And the administration and compliance and filing requirements that you've got, and the FCCA and the beneficial ownership declarations, there's quite a lot of admin involved, and you will have 2 tax returns and 3 tax returns, 2 provisional tax returns, and then an annual tax return, and you have a sub-C annual return as well, and you have a FCCA documentation. It gets more and more each year, so it's quite a lot of compliance to do, and the same with the trust. Then we've got the fractional property ownership structure, which Madeleine talked about a little bit. So I don't know if any of you know about the movement of doing a fractional property ownership. So ownership is also called a co-ownership arrangement, where multiple investors pool their resources to collectively purchase a tangible asset, in this case a property. Each investor holds a percentage of the fraction of the property proportional to their investment. So the pros of this is a low entry cost, it's a hassle-free management, it's exclusive use, and there's cost sharing. But it's not really suitable in the market for long-term accommodation. I'm touching on this because there were some questions about owning percentages of farms.
Yeah, can I say something?
Yes, please do.
So my understanding of this, when we are talking about agricultural land, once again, I have to point out Act 70 of 1970. You cannot own fractions of agricultural land. So if the property that we are talking about is not exempt from that act, the only way to do this is to register a company, and then you own shares in the company,
yes,
and your rights come from the shares that you own in the company. So once again, you do not own land, you own shares in a company.
Yes.
And then company law applies. So if, let's say, the majority of shareholders, 75% of shareholders, decide they want to sell this property now, and you fall in the 15% who do not want to sell, tough tacky, it sells. It's a majority. It's a 75% special resolution that you need. So just keep in mind that then you're dealing with a whole different, then we're not talking about property law, then we're talking about company law, which is a whole different ball game altogether. Yeah.
But there are a few members that have purchased land like this, so that's why I'm mentioning it, yes, just to answer a few questions. So, so you are buying into a company, and you then own 10% of the company, which means you own 10% of the expenses, 10% of the income. And a very important thing to look at when you purchase something like this is look at the user's agreement, because in the user's agreement it will stipulate what you can and can't do. So you can't, for example, put a borehole up on your land, you can't put this here. So the user agreement is what you really want to look at. And you also want to look at the financials of the entity and their tax filings. So it could at first sight look like a very great investment opportunity, but then when you look at the financials, it's a total different game. There's losses being made, losses being filed. And then there's also the very real matter of falling out with management disputes, because a lot of people can't decide on the same thing. There's always a lot of it's very similar to homeowners associations, where you see a lot of multiple people not coming together and not being able to agree on anything. It's not a great thing to resale. Resale values are very low because there's not really a market for something like this. And also very difficult to get a bond, because it's very difficult to resell. So if you wanted to get a bond, it's not a very easy thing to sell again. So the bond originators don't really like a scheme like this. Yeah, what else was there on this one? No, I think I covered everything on that.
Just one question. So, Madeleine, you saying this fractional property ownership cannot be applied to agricultural land?
No, it can. But it
Oh, it
needs to
can.
be in a company.
Oh, okay, then it's in a
And
company.
you own shares. But
Okay.
I must say, I'm with Celia here. I cannot advise this. To me, this is not.
You see too many fallouts and too many. So you would have different levels of management. Somebody manages the farm section, somebody manages the infrastructure section, and all those decisions needs to come together. And you only owning a 10% say in all of this, there's always disputes.
Yeah, and your voting right is also proportionate to the shares that you own. So, yeah, it's the fraction carries through all the way. So your rights in terms of that is also just your voting that you can in terms of the share that you own.
So it seems if you're considering this option, don't put all your eggs in that basket. Just make it like, well, if I lose it, if it doesn't work out, then it's okay because it's maybe so low that you could afford it. But then make sure this is not your only, like all your investment is in there.
Yes, yes, that would be a good way to sum it up. And for me, I think the most important is to look at that user agreement that they stipulate what you can and what you can't do and what you are responsible for at the end of the day. And look at the financials, scrutinize them with somebody that can help you, and the tax returns. Yeah, so that's my advice on that one. Selling your property. So if you're going to sell your existing property going into buying land, there will be capital gains taxes, and I'm just going to quickly brush over this because I think are we good for time?
Yeah, we're fine.
Okay, so if you are an individual, we said your inclusion rate is 40%, so that makes your effective rate of tax as high as 18% on your sale of your property. So that's just factors to consider when you're selling your property. You still owe the tax man a bit of money. If you're selling it in a company, remember the inclusion rate's 80%, so your effective rate then is 21.6% on that, and the trust as high as 36%. So just realize and think about these costs when you're selling your property, that you still have to pay the tax man some of that. How the capital gains taxes are calculated is you take your capital gain, multiply that by your inclusion rate, which we said is 40% for the individuals and 80% for the others, times your marginal rate. So your capital gain will be your proceeds from your sales, less your allowable expenses. Your allowable expenses will be your base costs. What's the base cost? The base cost is your original purchase price, plus your agent's commissions and any other fees, like your transfer duties and applicable fees. Your renovations, also called your capital improvements, can also be added to your base cost. So you really want to get your base cost as high as possible. And it's very important to note to keep all your receipts and all your documents in a row, because when it comes to proving to SARS your base cost, they want to see it. So you'll make copies and put them in the air. So then also we've talked about the inclusion rates. A quick example, if you wanted to go through that, of a capital gain. So if we look at the original purchase price of a property, say for about 2.5 million, and the agent took 200,000 of that, you had renovations of 400,000. So your base cost then would be your original cost, 2.5 million plus your 200 for the agent, plus your 400 for the renovations, which gives you a 3.1 million. Your profit would be you're selling it for 4 million. So you take off your base cost of 3.1, which leaves you with a 900 profit. In the individual side, if it's your primary residence, there will be no tax at all because it's less than, yes, the less that you get your 2 million off. If we say we sold the home for 6 million, there would be a 2.9 million gain, and you then take off your 2 million, so you sit with a 900 profit. With the inclusion rate, then your tax will be calculated on the 900, which leaves you with a tax of 47,632. So you also just need to remember that if you're running an Airbnb, that SARS might be scrutinizing that part and not showing it as a primary residence, but proportion some parts of it. Just an interesting fact to remember. Also, when you're claiming home office expenses, just see that it might be tainted and they might want a little bit of that exclusion drawn back.
Celia? So if you have the property in your spouse's name and your name, do you both get the 2 million rebate?
No, you share it. Yes, you share that. Yes. So in the company then, there's no primary residence or annual exclusion. For the example above, we will take the 900 Rand profit, and you will include 80% of that, giving you the 720,000. At 27% gives you 149,400. So you can already see, just at that first rate, the individual would have paid nothing compared to the company paying almost 200,000. And then in the second example, where we had the higher profit, the company would pay 626,400 in profit. So it does make a difference when it comes to reselling which entity you've got. So you have to consider those factors before deciding the entity to purchase your property in. So this is for later. So you're in trusts, the inclusion rate is also 80% and then taxed at 45%. But we've got the extra benefit of using the conduit principle. And the conduit principle is stating where the source of the capital of the tax can be distributed to the beneficiaries in the same tax type. So if you had the gain of, say, 626,400 in the trust, with the conduit rule, you can stream that down to your beneficiaries. So if you had 4 beneficiaries, you can stream that gain down to them. So you divided that by 4, and they will have their annual exclusion, and they will have lower tax rates than the trust. So that is still the preferred way of doing it. Although I must mention that SARS have got their magnifying glass over the trusts at the moment, and then we might see future changes in the tax laws coming to trusts, but at the moment it's still very favorable to do it in that way. Then I think this is my second last slide. Yes.
I just want to ask a question on inclusion rate. When you say 40% or 40%
Yes.
for individuals, 80% for companies, can you just explain that?
Okay, yes. So say in the example we had, where we had a 900,000 profit, only 40% of that 900,000 will be put in your box to be taxed as an individual. Whereas for a company, 80% of that will be included in your box to be taxed. So 20% of it's free, and then for individuals, 60% of that is tax-free. Yes. Exactly. Yes. Yes. So just a quick few things about bond applications. Being agricultural land, you would need to put down at least 40%. Sometimes you can get lucky to put down 30% with some of the banks. I just spoke to the lady and asked her, so she said sometimes you can get up to, 70% of the loan, so you need to put down 30%. For small holdings, it's quite different. It is like having a residential, and you can get up to 90%, sometimes 100%, if all your financial figures are looking very well. And then zoning. We said that if your land is zoned agricultural, you can also see it as a small holding if it's smaller than 5 hectares. Yes?
Sorry, I didn't know there's a small holding category, because I understood there was commercial, agriculture, and residential.
Yes.
What is the small holding?
It's if the land is smaller than 5 hectares.
So if it's agricultural,
yes.
if it's in an agricultural community and it's
It can
under
still
5
be-
hectares,
Yes.
how does
Will be
it?
classed as small holding. Can you explain a bit more about that?
So if it's zoned as agricultural land from a conveyancing standpoint and for the subdivision issues, if it's zoned as agricultural land, it's agricultural land, regardless of the size of it. Yeah. So you would have to look at the zoning. If a property is exempted from the Act 70 of 70, then the title deeds will be endorsed and it will specifically say that it's been exempted. So that's, I go back to where I started. Ask for a copy of the title deeds because that will help you see what are the conditions and what laws apply to the property.
So if it's not in agriculture, it's exempt of that law, it's in residential, how does it differ from another property being classified as a small holding? Does it actually get classified? I don't understand
from
that.
From a conveyancing standpoint, there's no difference.
Oh, okay.
Yeah, it seems like from
bond originators also, there's no difference. So they would look at your affordability, and they would give you up to 100, well, sometimes 100, but 90% of the loan. So it's different to agricultural land.
But where the difference comes in is with how you can own it in undivided shares or not. Because that's the big catch or the big thing to consider with agricultural land is can you subdivide it with or without the consent of the minister? Because that is it's not easy to get. Yeah.
And it's also interesting to note that different banks view the zoning differently. So I think it was ABSA that looked at 20 hectares as a smaller than 20 hectares is a small holding. And Standard Bank had also 22 hectares, and was it Capitec that had the 5 million hectare. So it's worth shopping around with the bond originators. You're welcome to contact me and I can put them in touch with you. It's actually a company that's based here in Somerset West that we've worked with for years. And they will be able to give you more detail on the different options you have. And then also we talked about the affordability. Yeah, just to know that if you're buying it in a company, the surety is always signed by the directors. So you are still signing surety in your personal capacity if you're the director of that company. It's just interesting little facts that I thought I'll mention at the end. Yeah, so and the affordability is also calculated differently depending on your entity. And if it's a farm, they will include the operations of the farm. If it's a small holding, they look at you as a person, as an individual, how much you can afford and what your personal situation is. And then also important is to document your intentions from the start. So say you're going to go into a small holding and your intention would be just to give it a go and see whether your crop will grow and produce and you can make a living out of this. It's important to document that from the start and to say, my intention is to put up a crop here, to sell it and get it signed and get it documented and file your first tax return in that manner. Because if you are just going to live on the farm as a lifestyle situation and you have no intention of selling anything or having it as an active little farming setup, you won't be able to claim any of your expenses that you would normally be able to claim in a small business like that. So your intentions needs to be shown and you need to fill in your first tax return with those intentions so that the taxman can see this was your intention. Even though it's making a loss, you can build up your losses. So you can claim all the expenses that you incurred in producing that income. So if you are, simple example, setting up a crop of carrots and the carrots didn't heal well enough, but you still bought all the seeds and you watered it and you were ringing around with your cell phone and you were driving up and down, you can still claim all those expenses. Whereas if your intention was just to go and live there, it's quite different. So make sure that your intentions are jotted down, signed, and filed in the correct manner so that it can't come back and bite you. So you can build up losses in that way. So I think the next slide, I think Madeleine talked all about the land transfer restrictions and also showing when it is the definition of the agricultural land, the minimum size requirement that we talked about now, it needs to be 1 morgen, and the restrictions on joint ownership. So It cannot be jointly owned by 2 or more unmarried individuals, 2 or more individuals married out of community of property, 2 or more legal entities. This prevents the imbalances that would make the land unusable for agricultural. And the whole reason behind this is that the agricultural sector is so vital to South Africa, providing food and contributing to around 20 billion in exports. Because of this importance, transferring agricultural land is governed by strict laws. So that is because it's producing all this, that they govern that. So the exemptions are if spouses are married in community of property, then they can jointly own that. And I think that is everything.
What are the requirements or the laws regarding, you know, if it's a residential property, let's say it's a small holding, but it's considered residential, not agricultural, can you have a business on there? Can you, let's say you've got space, you've got 3 hectares here, and you can like have a small little vegetable garden operation. Like, can you sell, how does that work?
Zoning, you'd probably be best at that.
Yeah, so
Maybe I'll just add something, because I know I saw in one property, but that was regarding the water usage. They were just saying, okay, water is only for personal use and not for...
Yes. So once again, it would be important also to look at your title deed, because sometimes title deeds will have a condition that says, for example, this property can only be used for the erection of 1 residential building. And then, you know, you can't, so you would have to look at title deed conditions and also zoning, whether you can. With zoning, you can sometimes apply, but then you'd have your neighbors have to consent, and they will look at things like what would be the increased traffic to the area. Can the roads handle that increased traffic? What would be the noise implications to the area? So you would have to get consent then to be able to do it. So there's an application that you can bring. But if your title deed prohibits it, that's it, then, yeah.
And Celia, my experience with trusts is that they're a lot of hassle and a lot of expense, because you are running, especially your scheme with a company and the trust, you have to have money to pay bookkeepers and submit tax returns if you aren't that way inclined, and most farmers aren't. So it's an added cost. Is there a sort of, well, let me put it this way. Seems to me that if you're going to have a trust, it needs to be a sizable property rather than a small holding with a few million to make it worthwhile.
Yes, I would say in the past it used to be quite an expensive vehicle to manage. Your setup costs will be quite expensive, setting up the trust and making sure the trust deeds and everything is professionally done. But then recently, I think with the cost, with the software, taking out all the pain in bookkeeping and things like that, you would find that the bookkeeping and tax fees have come down quite a bit. So it would be on par with running a company, because for the trusts, you would also have 3 tax filings in a year, the 2 provisional filings, and then the annual filing. And then just the upkeep of the trustees' documents. So just to make sure that you have a trust meeting every year, twice a year, when there's important decisions being taken, make sure that the trustees are coming together in a meeting and minuting everything. So it isn't as cumbersome as it used to be, is my experience, yeah. We wouldn't really see a trust tax setup more differently than a company. And it can be set up very simple, just to fulfill all your needs. It doesn't need to be so complex and so, yeah, I would see it as the same as a company these days.
And it's easy to get your money out of the trust when you don't have control.
When you don't have control. So the important part is just to, with your initial setup, that is very important to get that correct. Structure that with your needs going forward. But there are lots of ways also to assist people who has problems in getting the asset out of the trust. There's share for asset swaps that we can do. So there are lots of ways that you can actually, people get into a rut where they think, oh, I've got this huge tax burden that I can't get out of. So advise to see one of the specialists and see whether there's not just a simple way that you've not been looking at to assist you in getting through the hurdles if it was set up incorrectly.
Okay, thanks. And then, thank you. And Madeleine, for selling in agricultural land, do you need all the certificate of compliance for every building as well? All of that?
Yes, yes.
Okay.
So certificates of compliance are often looked at as just a nuisance to get through so that we can transfer. But it actually really protects, well, you as the buyer, because you know that what you are buying is compliant. So you will not a year later on be sued now by the municipality for not complying with things. That's the first thing. And the second thing, it also protects the seller. So whenever I advise sellers, I always say, sometimes they'll say to me, well, do I need a compliance certificate for this Wendy house standing outside here? And then my answer is always, you know what? Spending for a beetle, for example, spending 950 Rand on a beetle certificate for that is going to be much, much cheaper than if the whole building collapses and now you're being sued for damages and you have to cover legal costs for that. And just, it's a risk consideration. Yeah. It's just it's assessing your risk. That's what it is. Yeah.
Sorry, I seem to have a lot of questions. A lot of these houses on farms have been built 80, 100 years ago. Do they need plans now?
Okay, so plans is an interesting thing. So if you are applying for a bond, your bank will most probably want to see plans because they are assessing their risk. Okay, so it's sometimes difficult to get a bond if there are no plans. And yes, actually, you do need to have plans. So a lot of times what people do is they will actually make the contract subject to plans being approved. So things can carry on, but before we register, we have to have plans. It's the right thing to do, I would say. I think, it's good to have plans. Also for resale. That is what the law requires.
It's just a surprise for the seller.
Sorry, let me just say this. Yeah. So there is actually, there was a case where the court moved sort of towards the view that if you don't have plans, that actually it's because you need to have plans to have an occupational certificate. And if you can't occupy a house, then actually it's not fit for use. So, then you're actually buying something that you cannot use it. You can't use it for the purpose that it was created. So that would cause a lot of issues. So my advice would be ask for plans, make sure that there are plans. And if there are no plans, you can make it a condition to your sale to say, we are buying, but subject to plans being drawn and approved.
Okay. Sorry, my last question. If we're in a partnership and my partner wants to lease out a piece of land, does he have to ask my permission? Is there, because it's movable land?
What kind of land are you talking about?
Agricultural land, yeah.
So owning, a partnership is really, and Celia can also help me here, partnership is really just seen as two sole proprietors put together. So you wouldn't be able to own agricultural land in partnership because you would have an issue with the subdivision. It would be seen as subdivision. You wouldn't be able to own. Sectional title, yeah, so you can, partnerships can, but again, it's really just in each, so you own, it would be like buying property with your spouse, really. You would own an undivided share of a property, so you would have to be making decisions together. Yeah.
Yes. You said that one pays VAT or transfer duties. Is that just for agricultural land?
No,
or is
that's for all. That's for all property. So
okay.
The one thing that we can be sure about in this life is tax. Yeah. So tax, you're going to pay tax. The question is just which tax. Okay, so when we are buying property, it's either VAT or transfer duty. How do we determine which one it is? We look at the seller's VAT status. So if the seller is registered for VAT, then you pay VAT. If the seller is not, if you are not, VAT, if the seller is not VAT registered, then you pay transfer duty. But as Celia said, if you buy in an entity that is also VAT registered, then and you buy and there's a going concern, then it's 0 rated. Or if it's not, if there's no going concern, then there's 15% VAT, but you can claim it back. So it's input-output tax, and you can claim it back. So yes, you would have to have the cash flow to pay it up front, but you can claim it back when you do your tax returns. Correct. And then you can also claim back the VAT that you paid the conveyancer, because most attorneys are registered for VAT. So the VAT that you also pay there, you can also claim back.
And is this for, and how about new properties? Because I know here in the urban area, it's new properties, there's no transfer duty.
Okay, so there's no transfer duty because the seller is paying VAT. So new properties, you are talking about developments where a developer is developing an estate. The developer is VAT registered. So the developer, because remember, VAT is paid by the seller. And that's where, so I go back to my first, so yes, you're not paying that, but you are paying that because the seller has included it into their price.
Madeleine, I have a loaded question here. I'm looking for
Try
advice.
my best.
I'm looking for advice and giving advice at the same time. We purchased a plot 12 years ago, had clearly defined boundary walls. It's come to light that one of the boundary walls is in the wrong position. The neighbour wants the wall taken down and rebuilt in the new position. So we didn't get a survey done because we didn't think it was necessary. So now in hindsight, it's always best to survey what you're purchasing. What rights have we got in this situation?
Okay, so we are talking about something called acquisitive prescription. If that wall has been standing there for more than 30 years, then it can stay there. But prescription can be interrupted. So it's a very complicated question that you're asking. So when you buy property, maybe let me take a step back and start there. When you buy property, usually your sale agreement will have a clause in that says the seller cannot warrant the survey, cannot warrant that where the pens are actually where they should be. So, and that is part of buying the property, footsteps. Footsteps meaning you buy it as is, as you see it there. And so if the seller knew that the wall was on the wrong place and didn't disclose that, there are some, footsteps is also very complicated, can be very complicated. If they knew and they didn't disclose it, then you can possibly actually hold the seller liable. But when we talk about the laws of prescription, for 30 years, if for a period of 30 years, no one knew and everyone just carried on as this is the boundary and everyone accepted it, then it has now prescribed to you. Then it doesn't usually have to be moved. But again, it's complicated. It's not as easy as saying, well, it's been there for 30 years, so I'm not moving the wall. It's not that easy. But if the parties knew, then that 30-year period is interrupted. So for the time period that you knew, it's now interrupted. So then the 30 years doesn't actually run. So if in previous ownerships, people actually knew, and that's less than 30 years, then there's an interruption of that period, and you can't actually now claim that the wall stays there. So it's a complicated matter. And then, settlement is probably the way to go, to sit together around a table and just try and come to an agreement that can work for everyone.
That 30 years, does that apply to a servitude as well? Like a servitude to a property. So you've got a farm and you've got a road through it. There's no servitude registered. And that farm, that road's been through another property for 30 years. Does that sort of a clause apply in that aspect as well?
I'm not sure. Maybe. I'm sure the argument. I'm really not sure, actually. I'm not 100% sure. But yeah, there is an argument to be made that, if that is how it's been done for, law by
if it's been done for
habit, almost, you know. But I'm not actually 100% sure about servitudes as well. I would probably
So who would be responsible for the cost of replacing the wall? Is it up to the neighbour who wants the wall in the correct position to pay for it, or are you both obliged to pay for it?
It would probably be the responsibility of whoever's property it needs to be moved. So who's losing property or who's gaining property? You see, because someone's property is now becoming bigger than they thought it was, and someone's property is becoming smaller than they thought it was. Yeah. So it would probably be the wall. Yeah.
Sure.
Best would probably be to share it. Yeah.
But there's no clear legal decision on that.
And this is also, I mean, it is a little bit of
it's
property law,
complicated.
but it's also sort of like sauna medibira type of law, like
Yeah.
you know, like yeah.
So, maybe you can comment on this. Something that I found helpful was an offer to purchase is really, you're given a standard offer to purchase, and you can change that. So I'm not happy with that, take that out. So maybe you can just comment on that.
Yes, so the offer that you are making is exactly that. It's an offer. So agents, attorneys, I mean, we all work with sort of a standard document, and then with blanks, and you complete there whatever you want. But if something's printed there, it doesn't mean that you can't take it out. You are making an offer that you are comfortable making. So if there's something printed there that you are not comfortable with, you can take it out. That is not to say that the seller will accept it, okay? But that is the offer that you are comfortable making. And that's the best you can do, is to make an offer that you are comfortable with. Because at the end of the day, you need to carry those duties and pay. So make an offer that you are comfortable with. If the seller rejects it, so be it, you know? And I mean, as Christians, I think we should have that view that if it is the Lord's will, it will work out, you know. And this is obviously not legal advice. It's just my personal view in how I do, you know, how we view it. But I think that sometimes we're so scared that, well, they're not going to accept the offer. Well, then maybe they shouldn't accept. Maybe that's not the right place for you, you know. As Christians, I think we should also have that sort of belief that the Lord will make things work for us
if it needs
if it's the right thing.
Yes.
Yeah.
The tax side's feeling a little bit left out. Just something I forgot to mention to you that might be of interest if you were planning on selling up and moving into the countryside is there is a nice little exclusion if it's a small business. So then you get on selling that business, you get on your capital gains taxes, you get a 1.8 million exemption. And there's not a lot of rules to comply with. So you have to be at least over 55, and your net asset value of your company needs to be under 10 million. So that's also something to consider if you're packing up and selling up. You'll get your primary residence rebate from your house and your business, and there put your trailer on and go.
So Celia touched on Airbnb.
Yes.
So if your primary residence is using Airbnb, you would lose out on the 2 million exclusion rate. Is that correct?
No, it's just SARS have indicated that you might not get the full exemption, but they might proportion it to your area space where your Airbnb is. So say if you were getting the 2 million, they would proportion 10% of the floor space is Airbnb, so you'd proportion that part out.
So,
but we haven't seen it in practical terms just yet, but they have indicated that that might happen.
okay. So say your intention was to sell in a year or maybe 2. Would it be worthwhile stopping the Airbnb for a year? And would that then qualify, like, is it a year's tax returns or 2 years tax returns? Or how?
To be honest with you, SARS is not that equipped to look into it in that detail just yet. But to cover yourself, I would do a year without having the Airbnb.
Okay, thank you.
And weigh that up with how much you're going to save on the rebate versus how much you would earn in the Airbnb, and see which one is best. Maybe do it over the dry season.
That's also something I was thinking about when you were speaking about the
Home office.
No, not the Home Office, about the costs, the capital gains tax in a company versus, you know, you have to also weigh it up as to how much tax did you actually save during the time that you owned the company, owned the property. So, yeah, it does look, when you look at capital gains tax, the numbers look scary, but you have to look at the overall position. Yes.
That's why I said it's in the fine print. Look at there's no fit. You have to filter all this information into your unique situation. Yeah.
Sorry, just one, because I just heard people in previous sessions, they talked about it a lot. So people who were able to acquire a sizable farm, and at some point they're now looking at the community, and there are people who, families also want to move out. They're looking for solutions where they could accommodate these people on the farm. And that's where the thing is, like what structures would protect everyone and so on. But I think possibly what I've heard in today is from the owner's point of view, if it could work to convert it then maybe in a company, then you just make sure that you retain 75% of the...
You have the majority.
Of the shares.
Yes.
And keep it that way so you can act.
And you also have different classes of shares. So you can have different classes of shares set up. So non-voting rights and shares to land usage. So you can structure it the way you want it.
Yes, because resolutions are taken, I mean, the people who vote, those who have voting rights on that particular matter, those are the ones, you know, those who are who votes. So if they don't have voting rights on those particular issues, then and the voting rights sit with you, then obviously you can control it in that way. But speaking, and that's why I said, for me, I'm sort of advising buyers. So speaking from the buyer's point of view, that's not great. I wouldn't buy into something like that. There's just yeah, it's a risky investment. But it
could be your only way in.
I understand that.
So it might, and coming back to the other comment, if it's not your own investment, everything, but it could give you what you want from being in the country, but you understand what you're in for. Yeah.
There was also an interesting comment by somebody that said, look at a structure. It's a structure that's spilled over from America called farming together. But I didn't have time to research it. I don't know if any of you know. So it's a very low entry to this, and it's a scheme that came from America, and it's starting to happen here in South Africa. And like if you Google farming and living together, it's an American model that they're using. So it's people with almost no capital to put in, starting to work on these farms, and you work your way into earning your piece. So there's options. Oh, sorry, I didn't have enough time to research that part.
Yeah, I just again have to say Act 70 of 70, it's very difficult to have subdivisions of agricultural land. So I don't know how that would be structured. I also didn't look into it.
Probably like a kibbutz setup or something.
Yeah. I must just caution, like from a legal standpoint, be careful of all these American things moving in, because our law, we don't have American law. So, yeah.
And kibbutz?
I don't know.
But you know how kibbutz setup is? No.
I've got a question for both of you. It's not going to be an easy question to answer, but maybe you can just give your thoughts on it. As we're going forward, and we see that most people cannot afford country property, the majority cannot afford it. What I've been looking at, and I've been suggesting to the churches, what is the possibility of a church buying a country living property, which then serves its community? So the community would be able to live out in the country on the church's property, which possibly could be in the entity of a PTY Limited or something like that. And so you know, at the end of time, we don't, let's say Silverleaf Church here has 20 people and all of them have 5 million and they can go and each buy a property for 5 million. We've got all this money invested in property. But, you know, you mentioned in the beginning, the expenses of running a country living property are very high. So it's tractors and it's irrigation. Whereas if we pull in together more, we don't want to have all our resources sitting in country living property at the end of time. What would you think of an idea of where possibly churches would look at something like this?
Can I go first? Because you probably have much more to say than me. I would go for a leasehold option, where you have a leasehold's much more affordable for those type of people. Instead of paying rent in town, go for a leasehold. So you lease your property on the countryside, and you have options to renew it all the time. So that's the easier way to do it. So if you have an existing farm with farmland, the farmer will agree to lease parts of his dwellings. And you can still work and live and produce there.
Yeah, but that's probably the only way to, yeah, or creating a company. But I don't know how that would be structured, because that would mean every member of the church would have to be, I don't even know how to begin to answer that. Yeah, the leasehold is probably the best way, but again, remembering now that if it's a leasehold, you don't have ownership. And again, Act 70 of 70, the subdivision is an issue, so it will not be for longer than 10 years at a time. And if they don't want to renew, they don't want to renew. Yeah, that's going to be a difficult thing to structure. I don't actually know how one would do that.
It's going to be a blend, because there will be some individuals who are happy to purchase and do the whole thing and kind of sponsor the whole idea and the spirit of the whole thing. And they have the majority share in the company. And then that company can do leaseholds for other members who know what they're in for. That they don't have ownership, but they have some rights to actually go through with this experience. But you're going to have to find the pioneers who do it, and the rest will just have less rights. And that might be acceptable, you know, for everyone. You must just know what you're going into. You choose category A, B, or C into what you're going into this new village. And there are people who have done that. And in terms of commercially then going into it, there are ways of doing cooperative structures on the commercial side of this, I think. And it might actually be very attractive, because there are the CETAs and the DTA, and those things have looked favorably on if you're going to start some of these kind of agricultural things, and one can also look into that. There's funding available from other sources on that side of it. So yeah, I think it's going to be one massive blend of all of everything you've said, and there'll be some pioneers who's willing to kickstart it, is what I would think.
Yeah, I would also, I'm just thinking about church structures and just the red tape of getting to a point where we have a vote to be able to move. Yeah, to me, I think it's very complicated. Let me say this. I've had people come see me for advice, and I would say to them legally, I cannot advise you to do this. It's just not great. And they will say to me, thank you very much. We hear what you said, but we believe this is what we must do, and they carry on and they do it. So, yeah.
Okay, so yeah, do we have any further questions? I'm just glad the church is not too full, because they would never let you out of here. I think we have so many questions.
Regarding the 1031 exchange process between properties, you know what I'm talking about. Okay. Okay, that's going to be too long to explain. I'm going to leave this question for now.
Just say it again, sorry, there?
The 1031 exchange process between when you are selling a property and you get someone legally to hold the funds of that property in a separate account, so that when you don't actually take those funds into your account, so you can kind of avoid that taxation in that whole process. Not avoiding taxation per se, but that money gets transferred, gets moved directly from.
Are you talking about the money's paid into a trust account of or like a fiduciary administrator.
Yeah, and then it's kind of used in the upscaling of buying a new property, but usually that would have to happen within the same category of a property, a residential to residential building or commercial to commercial building.
Is it not the urban allowance?
I don't know. So you're investing money to be able to buy property. I know, I'm not aware of, I don't know what you're talking about.
We'll take this off.
Okay.
Sorry, maybe just a bit of advice as well, because we deal with a lot of body corporates and homeowners associations, and the advice that we've heard today with CELIA and the expenses that it's always best to make your money now. So when you want to go to the country, you have enough money to buy the piece of land, big or small, and to continue with the running expenses. And even my own parents' experience of buying a small piece of land, it's extremely expensive. My father bought a piece of land. He was a butcher. My mum was a baker. And my mum used to say all our money went into the land. Nothing came out. She wanted to buy a rental property and make income, which she did do, and was making money from day one. So if your intention is to move to the country, to make your money now, so when you can make that decision, you have your money to buy the piece of land and you have your money to run it, pay for the company, pay for the trust expenses, because it's going to be an expensive thing to do. And to make a living off a piece of land is also extremely difficult to do, to cover all the expenses. You really need another source of income. So invest wisely.
I think what you're saying is we need to be realistic. I think sometimes all of this is viewed in sort of a romantic type of way. Yeah, we want to live in the country and live off the land. That sounds wonderful, but practically, yeah, there's a reason why everyone is not farmers.
Yes, yes.
Yeah, Madeleine, I had one question. I remember somewhere along the line you made a statement, I heard you commenting. So you've made an offer to purchase, you've paid your deposits, you've got your bond approval, and it's in the process. A flood comes and washes half the building away. And I remember you mentioned that we need to look at what happens in that sense. Who's responsible? I don't know if you can maybe just...
Yeah, so until the day of registration, all risk and all benefit of ownership sits with the seller. From the day of registration, all risk and all benefit of ownership moves to the buyer. So it's important that the seller must keep their insurances up to date up until the time when registration takes place. But it would be an interesting question whether you would now be allowed to cancel the contract because that thing has happened. I don't think so. The seller will have to buy through their insurance, fix it up to how it was, because usually the contracts also include a clause that say the property at registration must be in the same condition as when you signed the contract. So it's all about when risk, and with risk comes also the benefit of ownership, so risk and benefit passes, and that happens at the moment of registration. Yeah. So it's also important to make sure that your insurance is ready to go from the moment of registration, because then all risk passes to you. Yeah.
Yeah, thank you. I think we can close. Thank you very much for both of your time. As you can see, there's lots of questions. We're not going to answer them all today. We really appreciate you touching on and giving us a lot of insight. Thank you very much. And I don't know if there's any closing statement any of you would like to make, if you'd like to each make a closing statement of something, some special advice or...
No, just save a lot and make sure you can afford it. Yeah.
And consult with professionals before you sign anything.
Exactly.
That is the best advice I can give anyone, is to consult a professional before you sign anything, because they will be able to look at the pitfalls and help you crystallize the issues as well.
Yeah, and don't be scared to spend money on professionals, because you spend that little bit of money on those professionals, they might save you millions in the long run. So, you know, we mustn't be afraid to pay for services.
Yes.
Especially as Christians, sometimes we get a little bit measly, you know, we want everything for free.
And probably the last thing I want to mention is if you are finding yourself in a very difficult tax situation and thinking I can't move forward because of this tax burden I have in my trust or in my company, and I actually want to move the asset out in my trust, but I can't, please come and see a professional, because there are ways to get you out and help you, assist you in getting the whole structure correct. So don't be burdened down about this tax obligation. Just
and things can be changed. Even when you set things up, things can be amended. You can amend trust deeds. You can amend memorandums of incorporation. So don't think that now
swaps.
There's always something to be done. You just need to know or see someone that knows
how to do it. Don't get burdened down.
Yeah. And on that note, if you get into trouble with your bond, I know we got into trouble with our bond many, many years ago when the interest rates went over 22%. And if I had known then, you immediately go and speak to your, maybe talk about this.
The worst thing to do is to do nothing.
Right.
The worst thing to do is to do nothing. So go and speak to immediately, yes. Speak to your bank. There may be an arrangement that they are willing to make. Just don't do nothing, because then you will get into trouble.
Yeah, because that's the lesson we learned. And the law does kind of protect the person who's borrowed the money as well. So
so when it comes to, especially when you live there, when it's a residence, then there are many things that protect you, because our constitution protects your right to housing. So it's something that all courts look at it. They have to look at and have to keep into consideration that our constitution protects your house, your especially the primary residence. So a court will not just, a bank cannot, you cannot just wake up one morning and now your house has been sold from under. That cannot happen. There's a very specific execution process that has to occur. So when you get a notice from the bank, again, the worst thing you can do is to do nothing. Deal with it, because there is most probably an arrangement that you can make for over a few months to have slightly lower installments. Your interest rate might raise a little bit, but protract your agreement for a bit longer, or there are all sorts of ways that you can negotiate with the bank, and they are generally happy to negotiate with you. But if you do nothing, then they will try to execute, because they have an interest to protect.
And it's the same with SARS, getting very vicious and attacking people. Don't do nothing. So if you are getting all these letters and reminders and dreigbrieven from SARS, don't do nothing. Come and see a professional. And like Madeleine saying, there's always something you can do. So if you show willingness, just paying a small amount per month, showing willingness, they will, and we've seen it quite a lot, they will write back penalties and interest and give you affordable rate to pay over a certain time. You just have to show what you have, show your affordability, and you can get debt-free. So the worst thing is to ignore it, because it just escalates an interest monthly, compound interest, and before you know it's this big snowball. So don't get bogged down by it. See a professional and tell them your situation. Don't get embarrassed by it, because we see so many people in that situation where you get so dragged down that you think you can never get out. But it's not true. SARS do look at it case-to-case basis, and we've got a very special person connected there that can help us to show your income, all your expense in the month, and show this is a little small 20 Rand I can afford, or 200 Rand I can afford monthly, and they will write back interest and penalties.
And
so
be honest about it. Be honest about it and be realistic about it. Don't say, well, I can pay X amount if really you can't, because then you're going to default again. And that becomes a problem. It's when you're defaulting on the arrangements that you have made, because now next time they're not going to be so willing to get into an arrangement because you didn't stick to the previous arrangement. So be honest, be realistic, but there's always something to be done.
We had an experience with SARS many years ago when I started with business, and I must say SARS was very, very good to us, very understanding. Yes. We were honest, we were upfront, we came with everything. And the other thing is pay whatever you have into, if you've got like a bond and you're in trouble, even if your bond payment is like 10,000 a month,
show willingness.
Pay 1,000 Rand if you've got 1,000 Rand, and eat bread and water. Whatever you do, pay your bond. Sell your car, get a lift from a friend, do whatever you have to do, but pay that bond, because once you get out of the property market, the costs, like we spoke, there's so much cost to actually get back in there, and all the legal fees. So if you get into trouble financially, whatever you do, beg, borrow, don't steal, beg, borrow, go to friends, ask for advice, eat bread and water, do whatever you have to do, but protect that bond of yours at all costs.
Maybe just a word like, when things are going well, pay extra on that bond.
Yes.
Yes, pay it off sooner.
Amazing that, I mean, just R100 extra every month, the difference that makes at the end of 20 or 30 years. You cannot believe. So, when you can, just kill that thing off as soon as you can, because the interest, the cost of borrowing money is astronomical.
Oh, no, thank you very much. Okay, so our next steps, we've had requests to cover the steps of country living. What are the steps that you would follow when you do country living? So that we'll be doing with our next country living essentials. So thank you very much for everyone who came and all those online. And if you've got questions, you know what's an incredible experience here at Silverleaf Church is we've had all these professionals within the church. We've had a soil scientist. We've had, he's an Silverleaf member who's a specialist in solar and alternative power. We've had an expert who is in canning. And look within your church structure. In so many of these churches, you've got plumbers, get to know the people, your community, and help each other. We really need to stand together in these times to help each other to be successful. We can't afford to make mistakes. Mistakes can often sink you as a person, and you can lose whatever you have because of costly mistakes. So let us close in prayer. Dear Lord, we thank you once again. We thank you for willing people to come and share of their expertise and help each other. And Lord, we pray that as we go forward in time, that we will form more and more of a community and stand closer and closer together as a people as we prepare to meet the last crisis that is about to unfold. We thank you. We thank you for wisdom, understanding. We pray this in your name. Amen.